And so we're going to move right into the next panel, the updates on college athletes, NIL, and celebrities' right of publicity. Coming up right now, without even missing a beat, Jonathan Goins. You're there, Jonathan, and Ron Katz. So you guys can just come right up. And we have our student moderator as well. Yes, let's get out of everybody's way. Yes.
Before we move forward, for those participating online, the CLE code for this session, so the CLE code 4B will be inclusion. CLE code 4B is inclusion.
So we get our, oh, there it is.
Just the arrow.
What? I'm glad you had a good trip to DC. And yeah. Awesome. Take care. That was fun. Yeah. Oh, yes, absolutely.
Okay.
Let's get everybody. Is this ready? Oh, you guys are ready.
Two slides.
Okay, so we are ready to start this next panel. And I'll turn the program over to this panel's moderator, current Howard University School of Law student, Daria Folsom, and you will lead this panel. That's right. That's right. Give your fellow students some applause.
Good afternoon, everyone. Welcome to the panel on updates on college athletes, name, image, and likeness, and celebrity rights of publicity panel. And my name is Daria Fogan. I am a second-year law student at Howard University School of Law, and I'm honored to be here today with our two panelists, Ron Katz and Jonathan Goins. And I will give the floor to them to present and to introduce themselves.
Just press that. Okay, thank you, Daria. I have been a sports lawyer for many years, litigated many sports law cases, and I've also spoken to law students for many years. And inevitably, when I do that, they come up and they say, well, how do you win a sports law case? And actually, it's very, very simple. You just have to find a defendant who is very wrong and very arrogant. And in the world of sports, it's very easy to find defendants like that. And in fact, I would say the NCAA may be number one in both of those categories. So the title, I tried to be a little bit cute with my title. We're talking about NIL, which is name, image, and likeness. So my title is NCAA plus amateurism equals NIL. It's nil. So I would go further than to say that the NCAA is wrong in this situation. I would actually say that the NCAA is evil. And I don't say that lightly, but I think that I can prove it. And one of the reasons I say that they are evil is that the main concept of the NCAA is based on a lie. And that lie is that there is such a thing as a student athlete. No other students are called hyphenated names. No other students are called like chemist athletes or artist athletes or musician athletes. So why are athletes called student athletes? And the reason is well known. It was invented in the 50s by the then president of the NCAA. His name is Walter Byers. And our source for it is Walter Byers himself from his biography. And basically, the term student athlete, on which the whole enterprise is based, is for one reason only, and that is to avoid the workers' compensation laws. There was a young man named Ray Dennison, and Ray Dennison was a football player in Colorado, and he died playing football. So basically, you think about it, under any moral system, under any legal system, if somebody dies doing something for somebody else, you would think they deserve compensation. And of course, in our American system, we have workers' compensation. But basically, if you say that someone is not a worker, but rather they're a student athlete, then according to the US courts, you don't have to pay workers' compensation. So the whole enterprise is just based on a lie. But the lying gets worse, because one of the things that the NCAA has always insisted is that the athletes are not paid. So I actually should congratulate Professor Matima and Howard on the 20th anniversary of this organization. And I've been proud to speak at most of the sessions of this organization. And I've always I've always used the same sort of stuff because I'm emotional about these things, like using the word evil and things of that sort. I have to say, a little bombastic. Some people might say that over time. So I've decided to change my style today. And since I'm at a law school, or an accounting office, I don't know, one of the law firm, and I'm going to use the Socratic method. But I know the Socratic method is a bit infamous among students because some professors use it in sort of a cruel way. I'm sure Professor Matima doesn't do that, but some do. We've all seen the paper chase and Professor Kingsfield, et cetera. So I'm going to use the Socratic method, but I am going to make very simple questions. The only person in the world who cannot answer these questions is the NCAA. So they're very, very simple. You just have to be completely dumb and evil not to be able to answer this. So the first question is, what is a job? You know, what does it mean if you have to go someplace for 40 hours a week or so, and there's a supervisor and he can hire and fire you? What does that mean? What is it? Somebody, please. It's simple. I'll give you a hint. It's a job. It's a job. But the NCAA doesn't call this a job, because if you called it a job, then you couldn't exploit people. You'd have to pay them. But does anybody know? Here's the second question. Does anybody know of any industry that is based on the concept of not paying its employees? I mean, there is no such thing. Only the NCAA. Only the NCAA. So what is the definition of a job? A job is a paid position of regular employment. And that's exactly what student athletes are at the big time athletic programs. So it says a paid position, but I've cut out the word paid because, of course, the NCAA insists that the athletes are not paid, even though in the case that was brought against the NCAA a couple of years ago, the judge found 17 different ways that NCAA athletes are paid. Scholarship would be the most obvious. But then the question is, what does it mean to pay people? What does it mean to pay people? Well, it just means give them money, right? Just give them money. It's not. Now, why doesn't the NCAA know that? Well, what's happened since we have NIL, since it's really, if I tell you I'm giving you money for NIL, or I'm giving you money because you work for me, or I'm giving you money for no reason at all, you don't really care. All you care is you're getting money. So what's happening in college athletics? Well, Adidas basically is now paying all college athletes in the D1 sports. And what this article says is from the Washington Post. It says its NIL network will be available to eligible athletes across 23 sports at the 109 NCAA Division I schools affiliated with Adidas. That could put compensation within reach of more than 50,000 participants. Now, they're not saying, Adidas is not saying we're paying these people to be athletes. They can't say that. What they're saying is we're paying them for their NIL. We're paying them for their name, image, and likeness. Well, I submit to you here, let's take Alabama, probably has, 100 people on his football team. Let's take the person who's number 100. Does anybody here know the name of that person? No. So it's fair to say that that person's name, image, and likeness has no value whatsoever. Yet that person will be getting a payment from Adidas. So the whole system is, just one lie sort of leads to another. And actually, I give the NCAA credit over all these years to make us think that this is even an issue. How could it be an issue that you have to pay people for work? I thought we settled that in 1865. Whatever. Okay. So how ridiculous was this whole rule when it was in effect? That you can't use your own, what do you own more than your own name, image, and likeness? You can't use it if you're an NCAA, or you couldn't use if you were an NCAA athlete. So as recently as just a few years ago, the number one athlete in football was a gentleman named Trevor Lawrence, and there was a hurricane or a flood or something, and he wanted to use his name, image, and likeness to raise money for the victims of that disaster. And the NCAA said, no, you can't do it. And then ultimately they made an exception, said, okay, well, we're going to let you do that. But how corrupt is an organization if they say that one of their leading lights cannot use his name in order to help victims of a natural disaster? I mean, the system has just gone off the rails. So it gets worse. Gets worse because basically we've got sort of a man bites dog situation here. What happened with NIL is that the states, my state of California, is the one who actually changed the rules on name, image, and likeness, because California made a law that students in California could benefit from their name, image, and likeness. And then another 20 or so states did that as well. So you had a situation where there was no athlete who was worth any money would go anywhere except to one of those states. So basically, because of that legislation, the NCAA changed its rules on NIL, saying, well, you can do NIL, but of course, we're going to make a lot of special rules and regulations about that. Apparently not realizing that people have been selling their name, image, and likeness for like hundreds of years. I mean, it's nothing, and they've been selling it in the free market. Supposedly we're a capitalistic society, but they needed to figure out rules and regulations. And then they tried to do it. And of course they failed. And so what they said was, well, we'll just leave it up to every university. Well, of course, we know that these universities like Alabama and Ohio State, they don't do anything to attract athletes. People just come there by coincidence, I suppose. So you're basically letting the fox guard the henhouse. And now they've realized it's the Wild West. So they're doing something that is quite unusual, because how many industries do you know that ask Congress to regulate them? The answer is zero. Nobody asked Congress. You'd have to be crazy to ask Congress. George Santos would be regulating. I mean, you just wouldn't want that. But the Power Five commissioners, the commissioners of the most powerful leagues in college, have now asked the U.S. Congress to regulate it, because basically they want to reassert control of some sort. And if they have a legal regime rather than the free market, then they realize that they could assert some form of control. So basically, what's happening? Well, guess what? Capitalism works. The free market works. So there's a young man you'll see some headlines say he's from Pittsburgh. He's from Pittsburgh, California, near me, a quarterback. He's the 7th ranked quarterback in the United States. And he's a very valuable commodity, and the big sports schools want him. So he actually made a deal with Miami, because basically what the colleges do, what the universities do, is they have boosters. The real people who provide the money are the boosters. And they've created what they call collectives for these boosters, and they feed in millions of dollars to these collectives in order to, even though it's against the rules to recruit athletes with money, somehow the athlete realizes that he's getting money. And in the case of Mr. Rashad, who's this athlete from Pittsburgh, he got $9.5 million, or he was offered $9.5 million from University of Miami. So that was good, but it actually wasn't quite as good as what he got from University of Florida, because then the University of Florida offered him $13 million. And so he did what anybody would do. He figured it out. 13 million is better than 9 million. So he decided that he would go to the University of Florida. The problem with that is this is sort of a black market. It's all under the table. So he has an agent. He actually has an agent who figures all this out. And he made this wonderful deal with the University of Florida. And then for whatever reason, we're not exactly sure, they said the deal is off. So that's a problem, because if I make a deal with Jonathan, for example, and we have a contract and he reneges on it, then I can just sue him, and I'd be glad to do that. Well, not Jonathan. I wouldn't sue Jonathan in any event. But if you make a deal under the table with the University of Florida and they renege on it, you can't sue them. So basically, the NCAA is complaining and saying, something must be wrong. We're amateurism. Everything is amateurism. This guy's getting $13 million. And Mr. Rashad's lawyer is complaining. He's saying, well, they reneged on a $13 million deal. I can't even sue them because the whole deal's illegal. So the system has just gone haywire. But don't worry about Mr. Rashad. He's now made a deal with ASU. Don't seem to have that. Anyway, here's the Pittsburgh QB says he's headed to Arizona State. So he's going to Arizona State, and he says he's very happy to be going there because his dad was a football player and his dad played at Arizona State. I doubt that his dad got $13 million, but whatever. And you can see that all the big universities have gotten in the act. Alabama has created one of these collectives. And one of the things that the NCAA is saying, well, we can't have this because then we won't have competitive parity. We won't have a level playing field. Well, guess what? We don't have a level playing field. I mean, does Howard have a basketball team? Do you think, are they going to be in the Final Four this year? Do you think they will? Do you think Kentucky will be in the Final Four this year? Yeah, could well be. Duke? Do you think Duke will be? There is no level playing field. The rich have always gotten richer, and under this system, they'll even get richer. But the players will also get rich. Some of the players, the best known players, will also get rich. And of course, we have a new world now, because now that the athletes are getting money, changes everything. So for example, it used to be if you were a booster and you made your contribution to the Miami University or whatever, it was tax deductible. You were giving to an educational institution. Of course, it wasn't for educational purposes. It was for people like Mr. Rashad. But now Congress is looking at this and saying, well, wait, if you're going to give money and it's going to end up for NIL, that's not deductible anymore. So that, it's really, it's hard to think of boosters as victims, but they are somewhat victims in this situation. And another thing that's coming up is taxes for the athletes. The athletes are now getting income, and they're going to have to pay taxes, and they're probably not going to be happy about that. But as my dad used to say, the more taxes you pay means more money you make. So I think ultimately they'll learn to live with it. And now we've come full circle because these laws that the states made, like California and Florida was one of them, are no longer necessary because we're now in the Wild West. So the states are viewing these laws now as an impediment to their universities' recruitment. So they're now repealing all of these laws because they're saying, well, wait, the Wild West is better than the laws. So they may be right about that. Then the NCAA, of course, is doing worse and worse every day. When I gave this speech 3 years ago, I said that the NCAA wouldn't be here in 5 years. I think I underestimated that. I think it'll be 4 years. But the latest sign is the NCAA has a new president, and he just started day before yesterday, and basically he is not going to relocate to the headquarters of the NCAA, which is in Indianapolis. So have you ever heard of a CEO of a company who's not located at the headquarters? I think that's a very good indication of where the NCAA is going. But it's even worse than that because the NCAA just can't get over the fact that they can control athletes. They just can't get over it. So they have to do something. So what is the latest thing that they've done? And this was just, this news item is from February 28th. And basically what they've done is you have all these people out there like Mr. Rashad getting millions and millions of dollars, millions of dollars. And then you have these two young women. They go to Fresno State. Now they're twins, the Cavinder twins, and they are very good basketball players. And it so happens they were just recruited to go to the University of Miami. Now, when they were recruited, they were invited to dinner by a booster. A wealthy booster. They were invited to dinner at his house, and he had a chef prepare a dinner for them as he was recruiting them. The NCAA said that that was a violation, and they suspended the coach of Miami for 3 games for that violation. Well, I think it's fair to say that the Cavinder twins do not have a lot of respect for the NCAA, and they made a TikTok. I'm not on TikTok, so I actually did see it. I asked one of my sons to show it to me. And in the TikTok, they do, some funny dancing and things of that sort. And then, I don't know if you can see it on the screen here, but it has the initials BFFR NCAA. Now, I'm not familiar with slang, but as I understand it, BFFR is not a sign of respect. I'll turn it over to my friend Jonathan.
Switch the slides. That was very good take, Ron, and I look forward to us partaking in further dialogue about that here in just a second. So the title of your panel is Updates as to both writer publicity and the collegiate sports context in addition to celebrities. So what Ron and I thought we would do was give you a 2-for-1 update on both writer publicity issues in the college sports context in addition to the celebrity context. So pleasure to be here as always, and look forward to having further dialogue. So I was involved in a case that lasted about 5 years. I represented Rick Ross, William Roberts III. He was sued by, I guess you could call a rival in the music hip hop industry, Curtis Jackson, better known as 50 Cent, based upon non-commercially released, and I put an emphasis on that phrase, non-commercially released, uh, mixtape album, about 26 songs, in which he basically took popular songs from the likes of Adele and Snoop Dogg, and basically the producer would strip the lyrics and then he would add on his own lyrics. Many of you would call that a remix or a sampling in that context. And so he did that. And one of those 26 songs happened to be 50 Cent's In the Club song, which in 2003 was the #1 song for that year. It was a top 100 song for that year. It's listed all time, one of the top 500 songs in U.S. history. Um, so creatively, because 50 Cent did not own the copyright in the sound recording, musical lyrics, or the overall composition, or masters, as the entertainment space would call it, he could not necessarily sue Mr. Roberts for copyright infringement. But towards the end of the remix of Mr. Roberts' version of In the Club, the last 20 seconds or so, it does then sample back in Mr. Jackson's voice, and particularly the hook. So, given time constraints, I won't go through that song, but you can listen to it on your own if you like. So he sued then for a right of publicity violation because he said, "Hey, you are using my voice without my permission," and we know the voice is a key identity element. It's part of a name, image, and likeness aspect. So his name wasn't necessarily used, his image was not necessarily used, but his likeness was used. And given the popularity and fame of the song, and the popularity and fame of Mr. Jackson himself in the entertainment, now TV, film space, he did not take lightly to that unauthorized usage, and then claimed that the misappropriation element was also met because Mr. Roberts, as a part of his mixtape, he would interweave in lyrics that would say the likes of him promoting his next album. So if you were to take the time to listen to all 26 songs, intermittently throughout a number of the lyrics, Mr. Roberts would say, "Only on the black market, coming out December 4th," because he was basically, the argument goes by the plaintiff, promoting his next forthcoming album. And that was thereby an exception to this copyright preemption rule. Long story short, Second Circuit affirmed the district court's opinion, which granted summary judgment to Mr. Roberts on the copyright preemption. Well, let me rephrase. Judge Eganton, federal district court judge, U.S. District Court of Connecticut, who's now passed away. As a matter of fact, he passed away prior to oral arguments on the Second Circuit. So should that case have been remanded, it would have been going back to a brand new judge. So Judge Eganton just made a broad preemption finding that Mr. Jackson's right of publicity claim was essentially contractually preempted because he waived away the right to exclusively assert a name, image, or likeness claim because of his recording artist agreement that he had signed with Shady Aftermath Records, better known as Dr. Dre and Eminem. And so the judge just went straight through the recording artist agreement and just said contractually that is excluded, and you waived away that right. And that's often the case in talent and celebrities, even in college sports, where athletes, when they're about to sign their scholarship and commitment,
When they're 17 years.
yeah, exactly, without a lawyer, no less. They're waving away, name, image, and likeness in exchange for having those promotions of them when they're playing sports. Well, the same is true in the music context. Recording artists often wave away certain rights in exchange for getting paid and in exchange for performance over sound recordings. That's starting to change a little bit. You're starting to see a lot more talent push back on that. So stay tuned on that aspect. So without getting caught up into the weeds too much here, the Second Circuit disagreed with that finding. They still agreed overall that the case should be dismissed on summary judgment grounds. I was thankful for that. But they focused instead on some of the other arguments that we had made in our summary judgment brief, which included Section 301's Copyright Act preemption. So Judge Eganton did not focus on copyright preemption. He focused on more of a contractual preemption. The Second Circuit said, we're going to agree with you, but for slightly different reasons. And so they went into affirming summary judgment based upon not just copyright preemption under Section 301 of the Copyright Act, but also implied preemption, which basically says any kind of state claim, regardless of what it is, breach contract, you name it, if that is the equivalent of a federal law, then you have implied preemption that's applicable. So the Second Circuit, in their 66-page opinion, spent excruciating time discussing both implied preemption as well as the Copyright 301 contractual preemption. Copyright preemption. Copyright preemption is a two-pronged test. It basically says, does the claim involve the same subject matter as the copyright? So it's a subject matter prong. And of course, that was the case with 50 Cent and Shady and Rick Ross, because the actual music that was at issue is a recognizable copyright. It's a musical work. It's also a sound recording. So that's first prong, subject matter preemption. Second prong is the equivalent test or the general scope test. In other words, does it look like a duck, walk like a duck, quack like a duck? Does it appear? Is it disguised in terms of your claim as vis-a-vis a copyright claim? And sure, you could certainly argue that, and that was the case here, because Mr. Jackson's issue was with the unauthorized use of his voice as recorded on a master recording that was technically owned by Shady Aftermath. And so, even the judges in oral arguments, I had to acknowledge that, sure, if Universal, who's also one of my clients, if Universal, or more specifically, NBC Universal, not to be confused, if Universal wanted to sue Mr. Roberts for copyright infringement, they could have, in theory, because they own that right, because they own the copyright. So long story short, there was this issue of whether or not, and by the way, so this was a case of first impression. This had never been decided before in the Second Circuit, surprisingly, despite the number of conglomerate and media companies and giants that are in the Northeast region, never been decided before. And right now there's basically a split among the circuits. So this issue is really ripe for the Supreme Court at some point. The Ninth, the Eighth, and now the Second Circuit make a very clear acknowledgement that copyright preemption can apply to a right of publicity claim. You have a few other circuits, including the Seventh Circuit, and that's what Mr. Jackson's lawyers were arguing, that, well, there should be an exception to that rule. So even though someone may have waived their right of publicity right via contractual preemption or some other disguised vis-a-vis equivalent copyright claim, if that unauthorized use goes so far as to be this vast amount of commercial advertising, then you can have this exception. So the case basically ultimately was status quo. It maintained the status quo, and a lot of major entertainment companies were relieved. And I got phone calls from them telling me they were relieved, because had that case not gone that way, had Mr. Jackson got his claim heard ultimately in the way that he wanted to, he basically could change the entire entertainment, music, sports industry on its face. Because then if you're trying to clear music and you want to play in the club in the background, basically what he would be saying is that you not only did you have to get a license from ASCAP, BMI, CSAC, performing, rights clearance from the copyright holder, but then you would also have to then go back to the artist and get permission from the artist. And you can imagine the difficulty in being able to do that, particularly for songs that involve a number of groups in which you have multiple performers. That's already hard enough to clear copyright, let alone if you have something like that taking place. But I want to acknowledge that the Second Circuit acknowledged something that came out of nowhere. None of the attorneys made any argument about this. The Second Circuit took it upon itself to say this when they were basically concurring with the district court. They said that while the district court correctly noted that under certain section of the recording agreement, Jackson granted to Shady Aftermath the perpetual and exclusive rights to utilize his name and likeness for the purposes of trade, yada, yada. That grant was exclusively only, quote, during the term of the recording agreement, close quote, which the parties appear to agree ended in 2014. Accordingly, upon expiration of the recording artist agreement, Jackson recovered a shared interest in his right of publicity and is not contractually precluded from bringing this right of publicity claim. So the Second Circuit, for whatever reason, took an extra step to not just disagree with the district court's analysis regarding contractual preemption. It then made an interpretation of the recorded artist agreement to say that basically now Mr. Jackson has a right to still sue other people for an in the club violation. Now, there was a survival clause in that recording artist agreement in which the assignment aspect survived termination. So I think the Second Circuit just respectfully did not have any full appreciation for the survival clause. You can't read one clause without the other. So yes, his agreement with the record label did terminate in 2014, but there was a survival clause that didn't. But that dicta, if you want to call it that, is still out there. And to me, it's just a matter of time before that particular issue gets litigated. Heck, I might even litigate that issue, depending on who my potential clients are on the plaintiff. I'm on the plaintiff side. All right, so fast forward to, and of course, this case it did not get a lot of press, I would say, in the more traditional legal context. But it definitely got reported on. Westlaw, Law 360, Bloomberg picked it up. So it definitely ricocheted in the entertainment industry for those who are into it, if you will. I knew though that it was bigger than that, and it's going to continue to be bigger than that. In only 2 years, in the middle of a pandemic, in which many court judges had to slow down their dockets, there's already over, and actually my number is now wrong, because when I did this last week, I then had one of my associates double check it, and I asked her this morning, what's the number? And the number is already 25 between last week and this week. So there's 25 publicly reported cases in which they're making published opinions, in which they're citing in the club, basically. They're citing the Henry Roberts, Mr. Jackson's case. So Mr. Jackson has made precedent, if you will, or they both have, I guess, in having a very significant impact on this tension between right of publicity and copyright law. And I won't go into it for time constraints, but One of those cases is the Genius versus Google case that is now on writ of certiorari with the United States Supreme Court. And in December of last year, they asked President Biden, specifically the Solicitor General, to comment on this issue, in which Google cited to my case 17 times in getting their case dismissed because they relied upon the copyright preemption doctrine. So, stay tuned. I think that this is going to continue to be evolving area, and I think it ties directly back into what Ron is also talking about, because you're going to have athletes that could literally rely upon Mr. Jackson's take and why they should still be able to work around some of these waiver issues. And not to mention, there are also issues involving social media influencers, TikTokers, their use of music. Same is true for college athletes, and we just saw that in an example that Ron gave us.
Thank you all so much for that great information. And I want to open up the floor for questions. You all online, you can definitely chat us in the Q&A box. I will check through to see if there are any new questions. But if no one has a question, I do have a question for both of you all. So starting with Mr. Ron Katz. So I'm just wondering, you think that the NCAA will dismantle in about 4 years. So what do you think the future of regulating collegiate sports looks like?
Well, I think it looks like what football looks like now. The NCAA has already given up on football. The NCAA has already given up on football. The football championship is run by a separate organization. So, and they've really given up on regulating NIL. They've also really given up on, aside from this case of the Cavinder twins, which is sort of a joke, they haven't really been disciplining people. Anyway, there was a recent case of Mr. Weissman, who was recruited by the Memphis coach to play basketball, paid his rent, etc. And it was a very minor penalty. So they're out of that business. Really, the only thing they do right now is they put on the basketball tournament, the big dance. And does anyone here doubt that somebody else could do a better job of that? Somebody like Mark Cuban or one of the sports entrepreneurs. So I think that really is also limited. And they've got some very nice buildings in Indianapolis, which are less occupied than they used to be because their current president is not going there. So if anyone wants some nice office space in Indianapolis, I suggest you could pick some up fairly soon, fairly cheaply.
Yeah, I think what needs to happen is Congress needs to step in and enact a federal right of publicity statute. As it stands now, right of publicity claim is a state claim, either statutory or common law. Almost every single state acknowledges some form of a right of publicity, law. So, why not federalize it? They certainly did that. That was one of the last acts that Obama passed prior to his tenure ending, the Federal Defend Trade Secrets Act. So if you can codify and make federal law out of what has long been state trade secret law, you can certainly easily do the same thing with a right of publicity claim. And then within that, they need to then specifically add a section that speaks to NIL for collegiate sports. And that would fix at least some of the problems in collegiate sports. Because right now, it's certainly having a state-by-state impact on recruiting, and it's going to continue to do that. And so, that to me is what needs to happen.
Thank you. And we have a question from the audience.
Yes. Hi, Claire Desmond from Under Armour. I actually have a question for each of you, and they're very different. One's a really quick follow-up to Jonathan's ending of his presentation. Why do you think Universal didn't sue Rick Ross?
Well, they didn't want to go around being known for going out after their own, art, and then he separately was signed.
Or not
to,
even sue, but correct. Reach out to him and be like, okay, give us a little money. And
well, and that's a fair point. It's a fair question. And I think the long story short of it is they without speaking on their behalf, I realize this is being recorded. They you have to be careful about going after your own.
Yeah.
And what kind of impact you could have with that. So even though he wasn't directly signed, obviously it was Mr. Jackson who was. There was some tension there about being offensively focused. And during discovery, that was something I put a lot of emphasis on, was the fact that there are so many different remixes of In the Club, including Beyonce herself,
Right.
who had did it on a commercially released album.
Yeah. Interesting. Thank you. And then my second question, if I may, Ron. So I think this ties into social justice in a sense that you mentioned Alabama. My husband's from Alabama. I became a football fan for Alabama like 6 years ago or so. But I'm thinking about what's the most likely remedy for thinking about college football, and you make it to such an elite college like Alabama, but you're not Jalen Hurts, or you're not one of the main people who would get a deal. And then you get concussions, you get these injuries, you're not even going to make it to the NFL. And this is actually across the board, thinking about athletes at schools not as prominent as Alabama, right, in football. What about like a health fund or other ways to protect these athletes who perform at a high level, kind of sacrificed or structured their college experience in a way where they sacrifice maybe focusing on what's after football, and then they have all these health issues? Is there anything that you can think of that could help them compensate for the issues they're going to have in the future, or like, is there anything in the pipeline that you think might be possible? Because I don't think the payment from NIL is an interesting development, but it's not going to help a lot of the athletes, the bulk of the athletes.
Yeah, it's called workers' compensation. I think that Roy Dennison, unfortunately, was a victim, just like Kurt Flood was a victim. He lost his case, and then ultimately he won. The players won the war, and ultimately the players will be considered as employees. The players will have the right to unionize, and the workers' compensation laws will apply to the players because they clearly are employees by any definition. Everybody in the world thinks they're employees except the NCAA.
Charlie Bingham from Splunk, and this question is for both of you. We saw the tension, and you mentioned Alabama, and she made me think about it. We saw Nick Saban kind of complaining in the news when Deion Sanders was the coach of my alma mater, Jackson State, started bringing in athletes, and they were going through the portal. What do you think the impact of Deion Sanders and kind of a leveling of the playing field with these NILs, where you have a superstar talent and this magnet like Deion Sanders, to the point where he can compete with someone like Nick Saban? What do you think that's going to do to the NIL rules and to the NCAA and the college program as a whole?
Well, it certainly has an impact on advertising, promotional marketing deals, and sponsorships. There have been studies conducted. I haven't particularly paid attention to them, but you could look them up. The city of Jackson, multi-million-dollar deals that are still in place right now. They will expire at some point, so it will be interesting. And many of the professionals in that city, I have a few cousins that live there, including a judge. They are very concerned about, okay, he made a significant impact for the city of Jackson. Multi-million-dollar deals from American Airlines to you name it. And I'm looking at someone who's over there at Under Armour, So what will happen, when those deals expire? Are they going to be renewed with Jackson State? Because all of those deals, it changed that city for the better in terms of revenue, employment opportunities, hiring, you name it. And I'm sure he's going to do the same. If not, he hasn't started already for Colorado.
Well, we have a name for this. It's called competition. And if Deion Sanders can compete with Nick Saban, more power to him. You know, I saw Deion Sanders play. I'd say I'd work for him for nothing. He was great.
All right, we have a few minutes left in our panel. Does anyone else have a question? All right, I have one more question. So I have a question for you, Mr. Jonathan Goins. So you were at the end of your speech, you were talking about, or you alluded to TikTok and different people using those platforms. So I'm thinking about creatives who have been going viral on TikTok and Instagram Reels for different clips of their voices, and then people maybe potentially using these voices in their videos, or the voice maybe being featured in a different song. So I just wanted to get your opinion about what do you think about that in terms of publicity rights and how these young creators who are going viral with these sound clips, what can they do to protect themselves?
So technology certainly continue to wreak havoc on someone's ability to protect and enforce their intellectual property rights. And we just saw that happen a couple of weeks ago in the Hermes case in U.S. District Court, Southern District of New York, in which they won a jury verdict against Rothschild, the creative NFT artist. So basically, what that case tells you now is that if you're a trademark owner, you need to be monitoring and watching the metaverse and all of the other digital asset platforms, because Hermes, it's like, be careful what you wish for, because while they had the right to enforce their trademarks against that artist, good or bad, that could be setting precedent that you now have to do the same, not just for the websites, not just domain name registrations, but also with respect to those kinds of platforms. So it becomes very complicated in terms of how you're evaluating protection of IP, because if you don't protect it, if you don't enforce it, you could possibly lose it, right? There's an abandonment defense that can be very problematic. But I, for my clients, I try to take a delicate balance. For example, I represent Gracie's Corner. Gracie's Corner went from 200 followers on YouTube to now 2 million during the pandemic. And they just were nominated for NCAA Image Award for animated category, as well as also being nominated with Nickelodeon for the same category. So yeah, I'm literally spending time with not one, but two paralegals in terms of trying to come up with a strategy for them, which I can help decipher. Okay, these are really bad. I've got to send a notice. I got to send a takedown notice to TikTok. Like verbatim, you are copying the exact language and the whole nine. But there are others where it's more of a fleeting reference. It's only going to last 20, 30 seconds. Do you really want to spend time trying to pay attention to that, or give more attention to that, in which you could unintentionally create more havoc, because they could take my demand letter and post it up on whatever. The next thing you know, they have a marketing problem in which they're then perceived as a trademark bully. So there's a delicate balance with that. And I think there's some unintended additional advertising that actually comes from the TikTok influencers. So companies need to be able to navigate and use them actually as an additional marketing voice, because it can be very advantageous in that process. And what you have to be careful for, though, is if, let's say, my client Tabasco likes a TikTok influencer in which they're making some unique recipe in which they're throwing in, the world's number one hot sauce. No plug there. And let's say McElhinney Company decides to like that post, and then it takes off and it gives the TikTok influencer another, 2,000 likes. TikTok influencers are becoming much more sophisticated now, and they are now sending their own claims implicitly, sometimes explicitly, to companies saying, hey, I just generated all this additional advertising for you. You should pay me something. So creatives are getting very creative about monetization, and to their credit. And there are a number of lawyers out there, just like you said, how do you find a defendant? You can easily find a contingency lawyer plaintiff who would do the same on the other side. And I'm dealing with 2 of those cases right now in California. Right of publicity, both involving TikTok, social media platforms. And companies have zero clue what to do because it's so, and I'm say that respectfully, but it's just so not foreign, but there's no precedence. Typically in-house lawyers, they can point to an outside counsel opinion, a memo that's written in which that outside counsel is then relying upon a bunch of cases. And they can then say, hey, based upon this precedent, based upon all this law, this is how you should make your decision, President, CEO. This is how you should make your decision, General Counsel. And that's just not the case with technology and social media. And it's not the case right now with NIL in a lot of ways either.
Well, thank you all both. That concludes today's discussion.
It was a pleasure.